Probate is a process. It's where the court makes a determination as to the validity of a will. People are generally overly concerned about it. It kind of is a nasty word. A lot of people like, oh my gosh, we got to avoid probate. As I tell people, if you have a nice, well-adjusted, friendly family, you can probate a will in six days or 2 weeks, depending on what the queue is at surrogate court. Everybody signs off, life is good. If you have a not so friendly family, you have a lot of animosity and your will is leaving people out, or people are concerned that the person you named is not going to be fair, then it could be fairly traumatic. And so in many ways, sometimes people do various techniques to avoid probate. For example, one way to avoid probate is the use of what's known as revocable trusts. So instead of having their assets in their name, they enter into a trust agreement by which the trust provides that usually they are the trustee and they are the beneficiary of the trust, but upon their death, they appoint another trustee, say another of their children, and the estate and their trust is to be distributed in whatever way they've determined. While that can be challenged, it's a harder document to challenge because it doesn't actually get in front of a court. Now, in some places, I understand, where it's very difficult to work through the court in big cities and things like that. These things are used quite a bit because it's not so much they're trying to avoid probate for fundamentally different reasons because of conflict. It's just easier to avoid the court, and so they set up these revocable trusts. Revocable trusts are also used, I use them, if you have assets in another state and you want to avoid what we call ancillary proceedings. So here's the common case there. The common issue there is you have a condominium in Florida. Now, if you die in New York and your estate is probated in New York, it'll work well for your New York assets, but it won't necessarily solve the problem of selling your condo in Florida. Then you have to get ancillary letters. In ancillary letters, all that means is the Florida court will recognize the New York court. Now, the only problem with that is, number one, you've got to go through all these documents and things like that. But number two, it tends to be expensive and time-consuming, and who wants to go through that process? Well, one way to do that is to avoid that is to put your condo in a revocable trust. So when you die, the trustee, it's already in the trust, the trustee then sells it. You don't need an ancillary proceeding. And you see that's a very common technique. I use it a lot for my clients. I suggest that for my clients who have these condos in Florida. And I think I'm led to believe it's commonly used out there just to avoid the whole estate proceeding that you would need to do if you don't do that. So that's one way people avoid probate.